Good morning, everyone. Before we get started, I understand we have some future public utility commissioners in the room. And I want to ask before we do the Pledge of Allegiance, because you're going to get to see what goes on in with this august body here today. But could our future public utility commissioners please stand to be recognized? Commissioner Gardner is a little chippy this morning. He's given out standing ovations. We do that at adjournment. But the first item on this morning's agenda, as we commence the 7th meeting for the Commission this year, is the approval of the minutes from the March 14th meeting. But I got ahead of myself. We actually do the Pledge of Allegiance. I'm on Santiago time. So with that, please join me in the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Apologize about that. And yes, the first item on this morning's agenda is the approval of the minutes from the March 14th meeting. And I believe, Commissioner Cawley, you are the editor of the minutes.
Thank you, Chairman. I have reviewed those minutes, and I move that we approve them as submitted.
Second. Any discussion? Any objections? Hearing none, the minutes are approved as submitted. It's a pleasure to welcome to the podium this morning to begin the public meeting Ms. Cheryl Walker Davis. Cheryl, good morning.
Good morning, Mr. Chairman. Good morning, Commissioners.
Good morning.
May it please this Honorable Commission, on behalf of your various offices and bureaus, we present for your consideration and disposition the following agenda items, commencing this morning with matters on behalf of the Bureau of Audits. It is recommended in omnibus fashion, for the one item there, that the Commission adopt the recommendation with regard to the Universal Service and Energy Conservation Reconciliation Rider on behalf of Equitable Gas Company.
So moved. Second. Any discussion? Any objections? Hearing none, the motion passes unanimously.
On behalf of the Director of Regulatory Operations, we recommend the adoption, on behalf of the Office of Competitive Market Oversight, of the recommendation pertaining to the proposal to issue a tentative order containing proposed procedures to facilitate electric generation supplier access from electric distribution companies of customer account data.
So moved. Second. Any discussion? Any objections? Hearing none, the motion passes unanimously.
On behalf of the Office of Special Assistance, it is recommended that the Commission adopt, initially on page 3, the recommendation pertaining to, it should be Cecile and Edward Coble versus Norfolk Southern Railway Company, as well as the 2 items appearing on page 4 through and including the recommendation pertaining to the former Bureau of Transportation and Safety, now the Bureau of Investigation and Enforcement versus York Cab.
So moved. Second. Any discussion?
Chairman, please mark me as concurring in the result only in Gary Gaskins versus Verizon, Pennsylvania.
So noted. And let's turn to the top of page 5 of the agenda. And I'd like to recognize, I believe, Commissioner Gardner, you have a statement you'd like to have entered into the record?
Mr. Chairman, we recommend the adoption of the staff recommendation with regard to the petition of the Office of Small Business Advocate in the proceeding involving Exelon and Constellation's merger, as well as Exelon's response to the administrative law judge's recommended decision in that case, noting Commissioner Gardner's statement.
So moved. Second. I'd like to recognize Commissioner Gardner for purposes of his statement. Commissioner Gardner.
Thank you, Mr. Chairman. I'd like for my statement to be entered into the record as if I read it in its entirety. On December 20th, 2012, ALJ Buckley issued a recommended decision denying the Office of Small Business Advocate's petition requesting an investigation of the Exelon Constellation merger. The ALJ found that the Office of Small Business Advocate failed to show good cause why the investigation was necessary. As such, the ALJ also reasoned that it was beyond his power to act in any way with regard to a stipulation of settlement entered into between the Office of Consumer Advocate and Exelon in that proceeding. Therefore, the ALJ recommended that the Commission neither approve or accept the OCA stipulation. Before us today are Exelon's exceptions regarding that we modify the ALJ's recommended decision with regard to the OCA stipulation of settlement. I agree that Exelon's request should be denied. That being said, I encourage Exelon to honor the commitments made to the OCA stipulation because they will increase the transparency of our retail electric market. Thank you.
Thank you, Commissioner Gardner. Any further discussion? Any objections? Hearing none, the motion passes unanimously.
In omnibus fashion, it is recommended that the Commission adopt the recommendation with regard to the complaint proceeding involving Guy Giordano versus UGI Utilities, Inc. at the bottom of page 5, as well as all items appearing on pages 6, 7, 8, 9, 10, 11, 12, and 13 through and including the petition for appeal of staff action in the proceeding pertaining to the Classic Limousine Transportation LLC.
So moved. Second. Any discussion? Any objections? Hearing none, the motion passes unanimously.
On behalf of the Bureau of Technical Utility Services, it is recommended that the Commission adopt all of the items appearing on pages 14 and 15 through and including the recommendation pertaining to RN Energy LLC, DBA, Kona Energy.
So moved. Second. Any discussion? Any objections? Hearing none, the motion passes unanimously.
Continuing with matters on behalf of the Bureau of Technical Utility Services on page 16 of the public meeting agenda, with regard to the first item there appearing pertaining to U.S. LEC of PA, Paytech, and Windstream's supplement pertaining to a collection fee for business customers, there is the motion of Commissioner Whitmer.
I'd like to recognize Commissioner Whitmer for purposes of her motion. Commissioner Whitmer.
Thank you, Mr. Chairman. I'd like my motion entered into the record as if I'd read it in its entirety. Before the Commission today are several tariff supplements filed by several CLECs. The tariff supplements were filed in December 2012 and January 2013, proposing to implement a collection fee of $12 for business customers with any unpaid balance when a previous month's balance has not been paid in full prior to the next billing date. The proposed collection fee is in addition to the existing percentage-based late payment charge of 1.5% per month for business customers. In accordance with our regulations regarding tariff filing requirements for ILECs and CLECs, the tariff provisions are currently in effect. In addition, no protests were filed, no hearings were held regarding the company's tariff supplements. In reviewing the submitted tariff supplements, the Commission's Bureau of Technical Utility Services extended the review period for 30 days as permitted by our regulations. In addition, TUS issued data requests to the companies in order to solicit additional information to assist in their review. In response to certain data requests, the companies indicated that their business customer contracts permit the imposition of a collection fee as long as they receive the applicable tariffs approvals by the Commission. The Commission's regulations set forth the tariff filing requirements for ILECs and CLECs, including cost support requirements. Specifically, Section 53.59E provides that the Commission may request relevant documentary support, including cost support from CLECs when they introduce new or revised rates that are higher than the corresponding rates for an ILEC in an ILEC's service area. The regulations also state that the Commission's request can only occur when it is necessary to protect customers, such as without limitation when services targeted to the economically disadvantaged or customers with poor credit histories. I believe that the tariff supplements filed by the companies do not invoke Commission determination to require cost data to support the imposition of a collection fee on business customers. While our regulations concerning tariff filings of this type by CLECs permit Commission discretion to request cost data related to new or revised rates for services, discretion only applies to rates for services which are clearly defined as non-competitive and competitive at Section 53.57. Because the fee that is being charged by the companies does not implicate the rates for non-competitive or competitive services as defined by both the current Chapter 30 and our regulations, I believe that Sections 53.59 does not apply here. Therefore, the Commission cannot use 53.59 as a basis to request cost data to support the $12 collection fee filed in the tariff supplements. Therefore, I move that the order approving the tariff supplements be modified consistent with this motion, and the Commission's Bureau of Technical Utility Services draft an appropriate order consistent with this motion.
Second. Any discussion?
Yes, Mr. Chairman, I will respectfully dissent on this motion.
So noted. Any further discussion?
Chairman, I also respectfully vote no.
So noted. The vote on this matter is 3-2, noting the dissent of Commissioner Gardner and Commissioner Cawley.
It is recommended that the Commission adopt the staff recommendation with regard to the application of Best Practice Energy LLC for an electric generation supplier license.
So moved. Second. Any discussion? Any objections? Hearing none, the motion passes unanimously.
And it is recommended that the Commission adopt the staff recommendation with regard to North Penn Telephone Company's tariff supplement pertaining to a simplified rate-making plan.
So moved. Second. Any discussion?
Chairman, let me, for my part, simply note that the company has utilized an 11.25% overall rate of return as the standard in this case, and in its simplified rate-making plan. This 11.25% rate of return is used for the company's operations in the interstate jurisdiction as prescribed by the Federal Communications Commission in the 1990s. It is a very old and I believe stale figure to be used as a cost of capital standard for the company's intra-state operations. But because the end result here is much lower than would be achieved for a revenue requirement consistent with the application of an 11.25% rate of return figure, I concur in the result only.
So noted. Any further discussion? Any objections? Hearing none, the motion passes unanimously, noting that Commissioner Cawley is concurring in result only.
In omnibus fashion, it is recommended that the Commission adopt the recommendations appearing on pages 17 and 18 through and including the recommendation pertaining to the security certificate of Lumos Networks of West Virginia.
So moved. Second. Any discussion? Any objections? Hearing none, the motion passes unanimously.
On behalf of the Law Bureau, it is recommended that the Commission adopt the items appearing on pages 19 and the first item at the top of page 20 pertaining to Verizon Pennsylvania, Inc.'s petition to waive its service quality regulations.
So moved. Second. Any discussion? Any objections? Hearing none, the motion passes unanimously.
It should be noted that the recommendation pertaining to the rulemaking for the recovery of fuel costs by gas utilities has been postponed until public meeting of May the 9th. Turning now to matters on behalf of the Office of Administrative Law Judge with regard to the first item pertaining to the complaint proceeding of Kurt Eckroth versus Verizon Pennsylvania, Inc. There is your motion, Mr. Chairman, as well as the statement of Commissioner Whitmer.
Thank you. I'd like to have my motion entered into the record as if read in its entirety. Before the Commission this morning for disposition is the initial decision adjudicating the formal complaint of Mr. Kurt Eckroth against Verizon Pennsylvania, Inc. In his formal complaint, Mr. Eckroth alleged that he experienced chronic issues with his telephone service and requested that Verizon PA be ordered to repair the facilities that provide him with service. In her initial decision, the administrative law judge sustained that portions of the complaint related to the service quality and fined Verizon $1,000. All other aspects of the complaint were dismissed. In arriving at her conclusion that Verizon provided unreasonable service, the ALJ relied extensively on Verizon's issuance of numerous bill credits to Mr. Eckroth. While I agree with both the ALJ's conclusion that Verizon provided unreasonable service to Mr. Eckroth and her imposition of a $1,000 penalty, I disagree with using the issuance of bill credits as evidence of unreasonable service. Bill credits, by the way, are used by all utilities for many different reasons, including as a customer service measure to keep customers satisfied with their service, regardless of whether they experienced a violation of the Public Utility Code or Commission regulations, or as a manner of settling disputes, as well as informal or formal complaints in accordance with the Commission's policy encouraging settlements. And then finally, compensating customers for issues for which the Commission has no authority to award compensation. I'm concerned that using the issuance of bill credits as evidence of violation of the Public Utility Code or Commission regulations will have a chilling effect on their use to the detriment of customers. In this particular case, there is sufficient credible evidence on the record to find that Verizon provided unreasonable service to Mr. Eckroth without relying on bill credits. Specifically, I note that there is a record of evidence that Verizon found trouble with the facilities that provided Mr. Eckroth with service 24 times between September 2009 and July of 2012. Further, the ALJ cited to the matter of Gary L. Gaskins versus Verizon, Pennsylvania, as support of her decision. I note, however, that contrary to the discussion in the initial decision, that Gaskins' decision cited was the tentative order, and as such should not have been relied upon in this particular case. Lastly, ordering paragraph number 4 of the initial decision directs Verizon to complete whatever corrective action necessary to provide the complainant with a level of reasonable and adequate telephone service that is free of dropped excessive distortions and noise, and send a report within 45 days to the Commission's Bureau of Consumer Services and the Commission's Bureau of Investigations and Enforcement. The record establishes that Mr. Eckroth is no longer a customer of Verizon, Pennsylvania, and is receiving telephone service from a competitive provider using alternative facilities, and as such, Verizon has no way of complying with ordering paragraph number 4. This ordering paragraph should therefore be modified to require Verizon to undertake these corrective actions if Mr. Eckroth or a successor resident of this address at issue becomes a customer of Verizon at any point in the future. Therefore, this morning, I move that 1, the initial decision in this matter is modified consistent with the discussion herein, and that the Office of Special Assistants prepare an opinion and order consistent with this motion.
Second.
Any discussion? Commissioner Whitmer, I believe you have a statement you'd like to have entered into the record.
I do, Mr. Chairman. I would like my statement entered into the record as if I had read it in its entirety. As noted, before us for consideration is the initial decision sustaining in part and denying in part the formal complaint of Kurt Eckroth at the above referenced docket. On December 5th, 2011, Mr. Eckroth filed a formal complaint against Verizon of Pennsylvania. According to Mr. Eckroth and verified by Verizon, there were service quality issues concerning the complainant's voice service at numerous times during a 3-year period. The testimony at the evidentiary hearing in this case indicated that Verizon made 40 dispatches to the complainant's residence in response to his service requests. Of those 40 dispatches, the company claimed that it found no trouble on the line 14 times, and twice found no trouble on the line because it was related to Mr. Eckroth's customer-provided equipment. I'm greatly troubled by this case because of the frequency and severity of the service problems experienced by Mr. Eckroth. As the record clearly demonstrates in this proceeding, Verizon made numerous repairs to temporarily address the service issues communicated by the complainant, but never made extensive repairs or upgrades to outside plant equipment to permanently address the service issues repeatedly experienced by the complainant. It appears from the record in this case that at least 24 service-related repairs did not prompt the company to take action on the complainant's service issues in a timely manner. Therefore, I fully concur with the ALJ's conclusions that Mr. Eckroth was rendered inadequate service by Verizon in violation of Section 1501 of the Public Utility Code and the Commission's regulations. Thank you, Mr. Chairman.
Thank you. Any further discussion?
I wish to associate myself with Commissioner Whitmer's statement.
So noted. Any objections? Hearing none, the motion passes unanimously, noting the statement of Commissioner Whitmer.
Continuing with the presentation of agenda items on behalf of the Office of Administrative Law Judge, it is recommended that the Commission adopt the remaining recommendations on page 21, as well as all of the recommendations on page 22 through and including Judge Colwell's recommended decision in the Duquesne Light Company Customer Education Surcharge Reconciliation Proceeding.
So moved. Second. Any discussion? Any objections? Hearing none, the motion passes unanimously.
Mr. Chairman and Commissioners, that does conclude the presentation of regular agenda items. Turning now to the carry-in agenda, we recommend the adoption of the staff recommendation pertaining to Sprint Communications Company's application for approval of a general rule indirect transfer of control.
So moved. Second. Any discussion? Any objections? Hearing none, the motion passes unanimously. We have approached adjournment hour, and in keeping with tradition of bring your son or daughter to work day, I'm going to call upon Kian Wawada. Kian, come on up. He's a future commissioner. It's calendar year 2025. I want you to all fast forward ahead.
I'm sure that he's a chairman candidate.
Definitely a chairman candidate. So here he comes. Now what you're going to do is you're going to take this. You're not going to hit Commissioner Gardner or the vice chairman, and you're not going to hit me. You can hit me if you want. But, and you're going to bang the gavel, and then we're going to adjourn the meeting. Then we're going to take some photos. How's that sound? Sounds like a plan? It's all yours. Here we go. One more time. On that note, we're adjourned, and I think we'll come back for an en banc hearing and let him bang the gavel again.